take some mental health because
I'm
something's
sorry?
wrong with you. You have
You
a
said
mental
what?
you have a mental problem.
I
If
have
you
a
think
mental
the
problem.
laws of the
How?
United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it.
The curtain rises on a classic sovereign citizen opening gambit that immediately sets the tone for the chaos to follow. By claiming she is appearing especially and not generally, the defendant is signaling her intent to challenge the very foundation of court's authority. It is a bold move that usually backfires, and Judge Washington's weary expression suggests she has seen this script before. The narrator wastes no time calling out the absurdity, framing this as a mental health crisis disguised as a legal defense.
Good morning. The 14B District Court is now in session. My name is Elaine Washington.
I find everyone's very funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anais Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anais Battle, appearing especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today.
This is quite tasty.
Battle, when you're not speaking,
You said, can I mute my mic when I'm not speaking?
correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law
Please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is not.
That sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in.
The defense strategy quickly shifts from jurisdictional wordplay to a desperate attempt at contract manipulation. Here we see the defendant questioning the validity of her own signed lease, suggesting that rights were never waived despite her signature being on the paper. The plaintiff's attorney is visibly baffled by the lack of legal logic, pointing out that you cannot simply decide a contract is rescinded because you feel like it. This segment perfectly captures the mounting frustration of a professional legal team.
Under the Landlord-Tenant Act.
Overruled.
My objection is overruled, Your Honor.
No, the objection is sustained. Her question that cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because
rescinded?
that's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to
Ma'am,
asking these
please
questions.
move
I will
on.
continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You cited a statute that I actually need to look up. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.
This is where the comedy of errors hits its stride as the defendant attempts to use the Magna Carta as a defense for not paying rent in the 21st century. It is a legendary sovereign citizen trope that never works, and the judge's response is a sharp reminder that we are no longer in 1215. The narrator's duck analogy hammers home the point that labels don't matter when behavior is as transparent. She is drowning in a sea of irrelevant common law citations, while her right to stay in the home evaporates.
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop talking. It says, a demand for possession or payment shall be in writing addressed to the person in possession and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there proof of service of it on the record?
That's a different question though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine. I didn't cite an exact statute, but I appreciate.
The technical sparring begins as the defendant tries to play gotcha with legal terminology, confusing a notice to quit with demand for possession. It is a cringe-worthy display of someone who has read a law book but understands none of it. She thinks she has found a loophole in the service process, but the attorney is 3 steps ahead, ready to correct her every mistake. The tension builds as the judge prepares to look up the actual statutes, setting the stage for a total collapse of the defendant's argument.
Cite it.
MCL 657.6. I mean, not 57.6, 600.5716. I just said MCL because they're both under NCLs. Both proof of service and certificate of service are both under MCL.
No,
All right, well, everybody, so let's not make my ruling.
Let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
okay.
is
Answer that question.
not on the disposition. And just like she read on 657:16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
object to it, I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next question.
And she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you objected me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear.
Just read-
I said either federally funded or get federal funds, which you do if you accept section.
Watch closely as the defendant's attempt to look intellectually superior completely implodes. After smugly citing a specific statute to prove her point, the judge reads the actual text aloud, revealing that the law says exactly the opposite of what the defendant claimed. It is a devastating blow to her credibility. There is nowhere to hide when the written law contradicts your entire defense. The attorney's final remark about citing statutes correctly is the ultimate professional burn in this legal showdown.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are, do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that these are the requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing.
The defendant's memory seems to fail her as fast as her legal arguments do, leading to a bizarre moment where she denies her own words from just minutes prior. Transitioning into a confusing rant about HUD grievance procedures, she tries to move the goalpost to avoid the inevitable. It is a classic stalling tactic used when the facts are no longer on your side. The landlord's representative is left wondering what the grievance even is, as the defendant spins a web of bureaucracy that has no basis in reality.
Move on.
Move on to, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If
Not-
I cannot have, this is not a fair hearing, and
No,
again, this is why
not, you're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the
Please.
laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts, but for some reason are hindering me in this proceeding, and that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not. And I told the Attorney General, and I told the IRS, and I did everything else because at the end of the day,
Please move
all
on.
of this is not right.
I'm telling you
And
now
attorney
that I'm going to be filing criminal proceedings against you for all these frivolous things that you're filing against me.
In a desperate final pivot, the defendant tries to weaponize federal funding against the landlord, claiming they are bound by HUD policies that she doesn't even qualify for. The narrator points out the glaring irony. She is demanding protection of a system she isn't even a part of. It is a masterclass in cognitive dissonance. She insists the landlord is an entity that must answer to a higher federal power, while the court tries to explain that basic rent collection doesn't require an act of Congress.
Feel that it's frivolous, that's fine, but it's not. My rights are not frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when it goes a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut,
Yeah,
that would constitute
this
as,
is cross-examination.
Battle, if
that
you're
would
not
constitute
going
as
to
the
ask
same
appropriate
type of
questions, then I'm
fault.
just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't
Well,
have a real opportunity to ask the questions. So at this point, like I said, I'm just gonna have to get the federal court involved and get the marshals because I don't know what you all are gonna do.
The finale is an absolute explosion of legal consequences. Fed up of being told she is wrong, the defendant resorts to threats, claiming she has filed complaints with the IRS and the Attorney General. But the judge delivers the ultimate reality check, threatening her with criminal proceedings for her frivolous and harassing behavior. It is a stunning conclusion to a case built on sand. If you enjoyed this courtroom drama, please like the video and subscribe to the channel, and we will see you in the next video.
Acting in honor and with good faith. So I don't know. I'm stuck on what to do. The integrity of the court is questioned.
with you. I don't know what that is, but you should seek some mental help because something's
sorry?
wrong with you. You have
You
a
said
mental
what?
problem. You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific. No, be specific because now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right.
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action. And I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with it right after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not saying, right?
Yes, that's not the law.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is. It's
All right.
backed in case law. And y'all keep muting me. It's okay. Because he can talk, but I can't talk.
Ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right,
Yeah,
so
okay.
what I'm going to do is grant your judgment in this particular case because I've given her an opportunity to present defenses that are real, and she has refused to do that.
I didn't refuse to present defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I've ruled that it's not.
I'm sorry?
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the last
That
piece.
your rescission is not a defense.
Okay, that's fine.
That is your defense.
Right, because, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction. You all accept and receive housing funds, making the subject
We're going
matter.
down the same road.
Okay, listen, stop. I didn't cut you off. I didn't cut y'all off. You just asked me what my defense was. And
All right, I'm done.
wow. You're asking me what my defense is. I can't.
Take her out. I've asked her 3 times to stop this. All right, I'm going to grant your your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes,
Thank you.
thank you.
I'm sorry
Thank
you
you,
had
Judge
to go,
Washington.
I'm
Thank
sorry
you.
you had to go through that.
All right, thank you.
Thanks.
Appreciate it. Bye.